much more, as I keep saying, for Latin America, which has got populations even bigger than you know than Africa, initial sort of individual states. So I think when we talk about these generalizations, there always must be. We must be cautious. They are measures. These are kind of boxes that political economists or whatever international organizations they like to package things, no, and not least professors Anna and Antonios. We as scholars like these neat packages of they make analysis. It is easier, but it's much more complicated than that. It's much more complicated. So that's, I think, one some what has got to be said about the differences. So
Evans,
if you look, yes, Anna.
I was just to make an observation. I think it's very fascinating. Huh? I was thinking about why so many complaints from Latin America,
Yeah.
and kind of a mystery. I would be curious to know if the same happens in uh, other types of complaints that does not involve freedom of association, for example, but I don't think so, maybe.
Yeah.
And I also think that one element that we could consider is that it shows that there is an expectation that the ILO somehow will solve the problem.
Yes.
Isn't
You
it?
are.
And it's interesting to ask why. Why is there this expectation here?
Yeah. In fact, Professor Anna, you have hit the nail on the head, and this is what we have had to contend with in the committee, because you must remember the CFA committee is very well represented by Latin America. Our leading members are from Latin America. Right now, I think we have got one from Colombia, definitely, who is the leader of the employers group. We've got, I think, two from the workers' side, and then government side now. Employers, in fact, we have got two as well. So we've got about 6 members of the CFA, and these are uh, very experienced and very kind of robust and strong members. And they always, part of the problem we have been sort of struggling with is to find an answer. Every conference I'm called by GRURAC. This is the Latin American group that until recently the Brazilian ambassador was chairing. And I've got to explain why there are so many cases from Latin America. And I always say, look, there is no way anybody would be not under my chairmanship would be targeting Latin America. I know what it is to be targeted as an African. Besides, I don't think Latin American representatives in that committee would allow me to do that. And they tend the Beto, that's the person from Colombia, and other colleagues tend to say, look, part of this tradition is that precisely what you have said, Anna. They tend unions and the others, they think the answers lie in Geneva. And I always tell the ambassadors that the answers do not lie in Geneva, they lie at home. In fact, the director general got into trouble one day, which he almost spilled onto my turf, and I had to sort of to backslide and say, look, the director general does not speak for the committee of committee on freedom of association. In fact, he reports to us. We don't to say, look, because he went on when they were criticizing the preponderance of too many complaints from Latin America. He carelessly said the problem is not in Geneva, it's at home. And they took strong exception to that. But that's the reality. There is this expectation that somehow Geneva will make good of this. That's a factor, but only a factor, Anna. I don't think it explains everything. So it's very, very complicated kind of situation. And what I keep reassuring the ambassadors of Latin America is that, look, the answer lies in sort of developing channels of social dialogue at home. Mexico apparently is making better progress than most in recent, in these last 2 years. And my sense has been, look, we've tried to encourage countries to sort of to benchmark in terms of what they are doing. That could help, but in terms of saying, look, the answer, not to put it so bluntly like the Director General, the answer is that it lies in social dialogue, that you have got to deal, that the social partners, the state must deal with the social partners. That if that is sorted out, I think they will begin to decline. Because remember, as I mentioned before, you do not have exhausted internal remedies to come to the CFA. Even though, routinely the CFA takes into account the fact that the government there might be a dispute, but normally you only take note of the courts. That if a complaint is pending before a court, then we have no business interfering in it. We will let it run. But that, as you know, takes a long time. So this is the dilemma that we sort of we find ourselves in the CFA. But the objective situation in reality is that most of the majority of the complaints are from Latin America. And I gather from the grapevine that really was a dynamic in terms of the composition of the CFA when they are choosing who to go what. Latin America has got to have a voice, and a strong voice. That is non-negotiable. And yeah, so Victor, if you can refer to 3, 4, and so if you talking of the different decades now, if you look at figure 3, figure 3 was the spread of complaints between 1998 to 2007. That's a decade. And figure 4 is a spread of complaints between 2008 and 2019. And you see there in terms of numbers, Latin America is still high up, 361, followed by Europe at 104, Asia and the Pacific, 83, more or less about the same with Africa at 89, and North America, 39. If you go a decade later, you have, in fact, the Latin America share has increased to 502, with North America declining, Africa declining, Asia Pacific also somewhat declining, and Europe also drastically declining. Figure 5, Victor, please. Is figure 5 there? Okay. So if you look at the representation of complaints before the CFA between 2007 to 2019, that is the picture you have. The majority, of course, still from Latin America. And even as they stop, in fact, the last figure there is misleading, because those 16 were the ones that were filed. In fact, 2019, we have got a backlog of almost over 70 cases that are pending, that we are trying to resolve, to decide on. Any comments or discussions, colleagues?
I still
of,
keep I'm
yeah,
still very surprised because I didn't expect so much importance of the number of complaints from South America.
yeah,
But I was just wondering if you have some other data to go further in terms of trying to understand different causes, some possible causes for this huge amount of
yeah,
complaints, such as,
yeah.
for instance, the internal conflicts between,
Hmm.
because
Hmm.
we have the monopoly of union
Yeah,
in Brazil
yeah,
here,
yeah.
and this is
Yes,
probably
yes.
one of the additional causes of the complaints to
Hmm.
this
Yeah.
extent. It's just
Yes, in fact, that is Professor Antonio. That is work in progress, and work that I keep. We keep talking about whenever the ambassadors summon me. That what we need to understand, not only from the ILO point of view, but from the country's point of view, is why this is so. The assumption right now is that this is due to the inability of the sort of external systems to function in terms of social dialogue. That's the assumed one, but that is not scientific in terms of, it's one of the assumed kind of responses. And I agree with you. I think it would be useful to take a very kind of seasoned study. And my sense is that it would be better, I think, if that study were undertaken by scholars rather than the ILO, because it's a very loaded kind of, complex kind of situation. Because the ILO, for better or worse, they are an interested party.
yes, I agree with you. I think it's our job, and
Yes, yes,
all the students and colleagues here
yes,
that are
yes.
sharing this.
So that would be
Yeah,
a wonderful kind
could be.
of project. Why is it? Obviously, as I think you cannot, even without that research, my assumption keeps to be that you have such robust unionists, but that is only a factor. And this, I mean, what Anna mentioned about the expectations that, go to Caesar every time. You have got to go to the ILO as Caesar to solve your problems. All those are factors, but I think we need a systematic research to establish why this is so. Is it cultural? Is this sort of the robust nature of engagement? Is it the institutions? Because one of the things, Prof. Antonio, that we struggle with in terms of these recommendations being implemented by governments, and it's not only Latin America, all over the place, is the lack of capacity to implement recommendations. So you have recommendations made. Some countries we engage and implement with them, not because there is lack of political will, but simply because they don't have the capacity. And even worse, I think in Africa is worse than some parts of Asia, than Latin America in terms of the ability. I mean, can you imagine Haiti at this point in time having any institution that is going to implement anything in terms of meaningful, effective in terms of freedom of association or protection of unions and civil liberties?
Professor,
Yes,
may I
Professor
ask
Wilson.
you? May I ask you? Is it possible to have a number by country?
Yes, I think we do have those numbers by country, but they are not in these statistics. We do have those numbers by country, and if you go, if you go to the website to the compilation, I
Okay.
think that, yeah, there is an index somewhere where it shows the number, the spread of what, yeah, chronological index of cases. So it's possible to have a sense of how many complaints from each country,
Mhm.
but we don't have an aggregated number. I don't have it for this presentation.
What I'm thinking as a researcher is if some country has more cases of
Yes,
complaints or
yeah,
grievance during a period, and another group of countries has another kind of complaints in the second period, for example, or or if we have the same the same countries having the similar numbers during all the time.
I couldn't say for certain, Professor Wilson, about that, but what I could say is that what we imply is in all countries, but including Brazil, the the number of complaints tends to sort of to go up and down, and I think you would find that they are related to at what stage you are in terms of a particular kind of period, in terms of government, or how your democracy is working. Because as we have one case here between the period 1964 and 89, that was one of your military periods. We I think Brazil had quite a lot of complaints, and it is to the credit of the ILO. So they claim that during that time they were able to engage the military regimes and be able to sort of to fight some way for trade union and civil liberties. So you are right, Professor Wilson, that I think it would help to try and to study exactly what happens, what times, and which countries in terms of patterns. Right now, I mean, to take just as a matter of way, I mean, the West country right now, and that's not hidden because there has been a commission of inquiry, is Venezuela, in terms of, it's so you can see it's patterns. The patterns are there when you have got a lot of political problems there. We have had quite a high number in Guatemala, Colombia as well. It's these countries, yeah. And Brazil, for all your sins, has has been a sort of has not always been sort of at the forefront of too many. But you are a big country, and sort of. So you can't read, and this is the other thing that I think one would need to go into in terms of a particular research. To what extent does the scale of industry, does the scale of population, and all those kind of sort of factors influence the prevalence of complaints?
Okay.
Yeah, thank you. Victor, the next one, please. Now, if we look at the origin and nature of these complaints, it's very interesting because what you have, as I mentioned, is that all these complaints in 2019, and that's the figure that is given here, originated from employees, from workers. No employee complaints from employers at all, 0%. As I said, that in a sense is a hidden hand. There's a hidden hand in there. Because a lot of these complaints that emanated from workers, for instance, and this is documented, you find that in the case of Guatemala, the intra and inter-union kind of complaints had employers' hand in them, not to mention the state. So they come to the CFA as complaints from the employers, from the employees rather, but in fact, the gestation of those complaints implicates the employers and always the state. So this is what more often, most of the time, the state anyway. So you had in 2019 a total of 89 complaints we considered. All of them originated from workers' organizations. And if you look at figure 6, that's what is represented there. But they are proxies. And in fact, you also have to take into account that unlike Latin America, In many other regions, notably parts of Europe and Asia, there is a whole cascade of complaints that do not originate from the national organizations at all. We are going to have a sense of that picture. A lot of them are initiated by international organizations like the ITUC and the human rights organizations. But the majority of the complaints that we considered in 2019, 65% came from the private sector, 29% from the public sector, and 7% from both sectors. That again is significant, I think, in terms of if you look at the political economy of many of the countries across the globe, that first of all, that the public sector, although it happens to be the biggest in many countries, actually tends to have less problems compared to the private sector in terms of freedom of association. And as I've mentioned before, the typical case is Japan, which is opposite to that. In Japan, you have problems in the public sector, even though Japan has ratified both 87 and 98. What happens is that doesn't exactly sort of fulfill its obligations, her obligations rather, under the conventions 98 and 89, 87. And this is remarkable because if you ask anybody other than probably the Nordic countries, Japan has got the best conditions for public employees. So much so that the general population resent it. They resent and they don't want, and we have been told time and time again that it's not simply a question of the government. The government would love to ratify and implement to implement what they have ratified, but public opinion is against it because the public servants already have what is seen as not only security of employment, a difficult thing these days, but their remuneration, and other conditions are much, much better than elsewhere. And in fact, we have had another case in Japan, which is interesting, of a group of temporary public workers, the municipal governments and, employ, but are given better conditions of service than if they were permanent. So when they offered them to be permanent, they refused. It's that kind of what, because they would not be so the benefits would not be as much as it's very similar, I think, with the pattern in domestic labor law, where some workers prefer not to be permanent sometimes because the takeaway pay is higher in some cases. It's that kind of mentality, not exactly, but it's that. So this is a situation we find ourselves in, that the overwhelming numbers are from the private sector. Not surprising at the legislative and institutional, let alone implementation level, because the public sector tends to be much better protected, and they tend to respond to the state's obligations much more readily. The next slide, please, Victor. And so there we are. In terms of the nature of complaints, it's a very telling kind of situation, because what you have here is the overwhelming nature of complaints are on against union discrimination, trade union rights, and the civil liberties, collective bargaining, protection against interference, and right to strike. And then they go down that way. So that's the spread of the cases. They tend to be more on trade union rights, civil liberties, protection against anti-union discrimination, and violations of collective bargaining rights. These are the most prevalent in terms of the global spread. Any comments, colleagues, questions? Okay, let's go to the next one, Victor, please.
Professor, just a bit more. Victor, could you go to the back? Yes, is it possible to enlarge a bit the screen?
Yeah, sure. Please go right on.
For me to read it.
Yes.
Is it possible, Victor?
To enlarge it or what?
To enlarge the screen because it's
Screen.
very.
Yeah, it's very small. Yeah. No, it's even smaller now. It's even smaller now. Yeah, even I am battling to read. Yeah, it's even smaller now, Victor. It was much bigger the last time.
Yes, I'm trying to zoom, but I do not have the knowledge to do it. I'm
Okay,
sorry.
No, never mind. So
I'm really sorry.
don't worry about that. We can manage to go directly to the other one, to the file, the original file that Professor Evance. Never mind.
Yeah. Okay. So the next one, Victor, please. So what we have here, figures 9 and 10, I think, and 11, and these are interesting. They are interesting in measuring the effectiveness and impact of CFA intervention. And what the committee now does is that it has got different categories of complaints. It has the serious and urgent cases, and it has got agent appeal cases. And overwhelmingly, in 2019, we only had 7 serious and urgent cases. And these cases normally tend to be the imprisonment of, trade unionists, breach of, trade union rights and liberties. And then the agent appeals also tend to be very much kind of related to a breach that involves either violence or against particular unionists or debts. And those.
Professor, do you have complaints for not respecting the right of strike?
Yeah, yes. I mean, it's yeah. If they like, in fact, there are quite a few come. Yeah, if there is no right of strike, in fact, you find that in many kind of jurisdictions, in spite of this current problem I referred to about some of the employers questioning whether the right to strike existed or not, a lot of national legislation does have the right to strike. Not all of them, and a few complaints relate to the infringement of that right. And those normally, and sort of, unless they are like the typical in recent years, the typical ones have been in Afghanistan and Zimbabwe, where there is, and the Eswatini before the 10 round, where there is a lot of violence, suppression of those strikes. Where they will fall into the category of serious and urgent cases. And in terms of the agent appeal, these tend to be in Cuba and then China and Russia sometimes, where you have got an international organization appealing urgently, for the release of particular particular trade unionists. And that has been a very difficult kind of difficult set of cases. For instance, we have battled with China. To this day as we speak, there are about 32 unaccounted for trade unionists that we are trying to find. When I sort of the Chinese leading delegate to the 2019 International Labour Conference confronted me complaining against China. I think I mentioned this. He kind of reproached me on how he could find China to find, 32 missing people when there are billions of people. And I sort of gently said, that China has got the most efficient administrative system in the world. If you want to find them, you will find them. In any case, one disappearance is too many, because that is against your obligations to secure the safety of these trade unions. And so it tends to be a question of mostly agent appeals, as well as Cuba. Cuba was, I had an interesting encounter with the ambassador, sort of in terms of some of the trade unionists that were detained there when I took it up with him. Very forthcoming, and reminded me, as he always does, that don't forget that Cuba was a founding member of the ILO, and we are committed to the ideals of the ILO. We have even a trade union movement there that is pre-revolution. We have given it space. Union rights are exercised, except for the criminals. So these people we have in the world, they are criminals, as far as we are concerned. And you shouldn't be championing them, because these are common criminals. It's got nothing to do with the trade unionists. And then, funny enough, before the conference was over, I was sent for and said, in any case, as a matter of goodwill, this is the centenary. I have word from Bana that we have released your criminals. So I hope they don't repeat it anymore. I mean, it's that kind of conversation that, you have states like China and Cuba that insist that they follow the patterns of freedom of association. It's guaranteed in constitutions. It's guaranteed in various laws, that people who end up being sort of folly of the law are actually criminals, that it is outside kind of interventions that are encouraging that. So, and this is the pattern that emerged at any rate in 2019, that the overwhelming cases were either non-agent or others, as we put them in that. That doesn't mean, in fact, maybe it's an oversimplification, because in terms of the breach of freedom of association rights, a lot of them are actually serious. But what distinguishes them from serious and agent is that normally, probably, people won't be in prison, they won't be violence, and they won't disappear. And therefore, the sort of the overwhelming category in both cases, that is the serious and agent, and also agent appeals, are ordinary cases. Vic, please. Yeah. And that is where I mentioned this in passing, that in 2019, what we had was the overwhelming number of disputes were presented by national organizations, particularly in Latin America. That has got to be said. There was very little by comparison in terms of those being presented by international organizations. It normally tends to be in Asia, China, of course, the Caribbean, Cuba, and then Africa sometimes that you have international organizations, sort of representing complaints, and sometimes it will be both, as in the case of Zimbabwe, both national and international. So you have, in both cases, you have 15 of those complaints, whereas those solely presented by international organization are 17 against 57, and as a percentage, I think 17 is quite high compared to the rest of the world by international organization, which I think suggests quite clearly that in a lot of jurisdictions, the unions are not viable and they can't they don't operate as freely as they should, at any rate to complain about their freedom of association rights. Next one, Victor.
Professor Evans, please, you said about international association. What sort of international association? Unions, international unions?
No, I mean, there's that distinction, Professor Antonio. International organization is at the ITUC, International
Okay.
Trade Union Congress, and you also have sector, what the Transporters Union and all that, seafarers and all that, and sometimes Amnesty International, and Human Rights Watch and all that. Yeah, those are the international organizations. And sometimes there have been cases, not last year, that will originate by the way of the ECOSOC, the UN, as complaints on human rights infringements there, dealing with union rights, freedom of association, and they will end up. But last year we didn't consider any of those. So the internet, but mostly when we talk of international organizations, these are not UN agencies. They are kind of NGOs and the trade union international secretariats.
Thank you.
Yeah, thank you. So next word, which I've already, Victor. Yeah, and as I was saying, interventions in serious and urgent cases normally involve human rights for personal freedom, trade union freedom, employers, organization as a whole, sometimes in states of emergency and the dissolution of organizations. And, that was the figures shown in 7. In fact, they were to be more effective. 7 out of 8 cases were examined in 2019. In agent appeals, where government put on notice and CFA follows up, invoked the follow-up procedures, these tend to be either to governments during the International Labour Conference or permanent missions in terms of the paragraphs 6 to 63 and 69 of the compilation. And those, as I keep saying, are the complaints that really preoccupy me after the sitting of the conference. That I'm either summoned by ministers and ambassadors, either they are unhappy, to explain myself, or to convince me, as in the case of Iran and Japan, for instance, that in fact they are doing the right thing. That we are being too harsh on them, rather than sort of patting them on the back. So I spend a lot of time trying to follow up with these cases, and that actually tend to be a much better response. Last year we had a favorable response of 12 out of 13 of those cases. At least there was some movement in terms of progress. Either the state undertaking that they will institute some revision, labor law revision, labor legislative revision, or that they will sort of they will age particular agencies. And this is the other thing that you probably, I don't know how it is in Brazil, but in some Latin American countries, I gather there are offices of prosecutor generals that prosecute labor matters. That deal. There are particular offices that where complaints concerning trade union rights and the civil liberties. If there is that connection, there will be an office that is charged in Peru. I gather it's one example that will look into particular disputes. And we have had instances of those cases where something simply grounds the heart. And the government will explain, look, the Ministry of Employment and Labor would really like to comply with what the ILO has recommended, but it's not within our jurisdiction. And that, by the way, is the issue also with federal states. I don't know whether you, Professor Antonio and Professor Anna, you know of instances where there has been a disjuncture between the state and the federal government. I'm not sure what the division of responsibility is in labor matters, but we do get that kind of argument where they say, look, we have handed it over to a particular agency. And although I keep, Japan is a favorite of mine. I keep referring to Japan because they are really committed to the ILO, but they have been many times they remind me that the Ministry of Employment and Labor, sort of wants to implement the ILO standards. That's why they ratified those conventions. But the policy and implementation of that is in the Human Resources Ministry, over which they have got no control, that they have got to negotiate within government to persuade those agencies. Of course, the standard answer from the ILO is that it's your responsibility, but it's much more complicated than that. And more often than not, we try to sort of the office, the secretariat of the ILO tries to help these ministries out by whenever they go to these missions, various missions, to engage those particular departments and more or less encourage them to say, look, the obligations that a particular country, undertook are obligations of the country, and therefore they should help as much as possible. Any comments, colleagues? Could we please take a comfort break? 10 minutes,
Yes.
Professor Antonio, please.
Yes, Professor. Just before the break, Ana Virginia reminded me to tell the students and the colleagues here that we have currently opened 2 call for papers. One for the also Anna, why don't you go ahead and tell directly yourself?
Yes, the ILIRA World Congress, the call for paper is open, and I put the website, the link for the website of the comments, and also the LLRN conference next year. The call for papers is open.
Okay.
I think it's until October 15. Both one conference, the ILIRA one will be in Sweden, the LLRN in Poland. Probably they will be, I don't know if they will be by remote and presential. We don't know yet. And but they're both great conference, and maybe Evance can talk because he is a former president of ILIRA. Can talk a little bit of ILIRA.
No, just to encourage everybody, and of course, both Professor Anna and Antonio, you are active members in that, and it's not only Anna, it's not only individual papers, but you can actually have session where you have a theme, and you, as a group, you want to do that. So they do make provision for that, and
Yes.
maybe this is a kind of what you might think, like a research group. There are also study groups, and Aniu is the father of study groups. So it's sort of
Yes.
those that people ought to be aware of. There are study groups which I think are quite good for emerging scholars, to get acquainted with what's going on in particular areas. Yeah.
Mhm.
Okay.
Okay, and also, Victor, are you in the room? Are you in the room?
Yes,
Okay.
Professor. Yes.
Just to reconfirm that we're going to receive also Professor Julia Tomasetti from the City University of Hong Kong, and
Oh,
Yes.
it will be a
okay.
great opportunity to be in touch with some Asian
Yes, yes.
specialists about
Progress,
issue.
yeah, yeah, right. Yeah, no, no. That's great. That's great, yeah.
Okay, 10 minutes
Confirmed.
break.
Okay, okay. Let's come back at, yeah. Thank you. Hello? Hello?
Hello.
Are we back? Can
Yeah,
we resume, please? Can we resume,
totally,
please?
totally back.
Okay,
Entirely.
thank you. Thank you. Thank you. Yeah, thanks. Welcome back. Yeah, let's continue. With where were we, Victor? Can you get me to the next, please?
Okay. Okay, Professor.
Oh, thank you. Yeah. Yeah. Okay. Yeah. Thank you, Victor. As I said, the last before we took a break, I was looking at the type of cases. There is another categorization that the CFA uses in terms of the cases that come up. And the reason for this now is that the constituencies, I think for quite some time now, wanted to know for certain where these cases are, at what stages these cases are. They felt that the committee itself felt that there were too many cases just being open-ended. So they introduced categories of active cases and follow-up cases that were examined. And then if you are within that category of active cases, you have definitive cases in terms of reports. And when you say definitive reports, those are the reports on which the CFA makes recommendations to the governing body to sign off, in which case the members now are seized of the responsibility to implement those recommendations. And last year, there were 25 such cases reported, which formed 40% of the total number of active cases. But there is another category, which is interim. And normally what that means is that when you have got an interim report, more often than not, there might be some information outstanding, either from the complainant or the state response. And those were about 22, in which the CFA issued interim reports pending further information or engagement. And then there were 16, 25% of the cases that the committee simply wanted to be kept informed. And these are usually cases in progress where the state parties, member states that were concerned are implementing some measures, and the committee simply wants to be informed in terms of the progress of those those efforts in implementing the recommendations. And then, of course, there is the close-up kind of file, and this is a very interesting category because it consists of not only cases which have been followed up for years and haven't come to anything, but in some cases, these are cases that have actually been resolved, but inadvertently left open. So it's housekeeping in terms of making sure that the follow-up cases are closed cases closed off, and there were 9 of those, which is 35%. And then there are cases to be followed up. And normally these will be from the interim report kind of situation. And those were 17, amounting to 65%, and the total being 100. So that has been the pattern last year in terms of pending cases, those reported on and the recommendations made, and those that are being followed up, and the others that have been closed off. So it's closing off, I think, will normally mean either the parties have disappeared, and there are instances where the complainants, simply stop following up. Unfortunately, they may either have been disestablished or overcome by more recent developments, or no progress has been made, and the state somehow has found a way of dodging responsibility, which is not unusual. It does happen. And there are kind of what I think one member of the CFA called veterans of evasion, where states there will be year after year, recommendations will be thrown at them. Year after year, they will have some explanation or other, until eventually things just seem to drift off, either because there isn't a rigorous follow-up, or because the circumstances have cooled off, particularly in instances of change of regime, in instances of abolition or stoppage of emergency and so forth. So you do have those cases that just fall off the table. Next one, Victor, please.
Professor Evans,
Yes.
just curious to know, and I think our colleagues and the students would also would like to know exactly how is the procedure to decide which cases will be submitted to the table, put on the table for decision, and what is the process, who decides it, and how many cases you decide at once?
Yes. No, thank you very much, Professor. And that's an important question, because basically the lodging of complaints is normally done by either by the parties who are entitled to. That's the trade unionists mostly, as we have seen. Even employers have got that right, or international organizations. And what they will do, normally they will write in to the office. Because you remember, at least in Portuguese and Spanish, you differentiate between the organization and the office in terms of the terms. In English, the ILO means both the organization and the office which is the secretariat. So complaints are sort of submitted to the office, and the office vests them, not deciding what will go forward, just to make sure that all the criteria have been followed. Remember, the complainant organization must be eligible to complain, they must be signed, and certain documents must be submitted. So they do that vetting. And there are times when, in fact, the substance of those complaints, either because they have been overtaken by sort of negotiation, or they have, for some reason, will not get through to the committee. But we do, at least since I took over, what we do demand of the office, that we have sight of all the cases that have been submitted. They must be explained. They must explain to us as to why we are not going forward with particular cases. So that's the process. And normally, as I said, you would have about 90 or so cases. And every session, we normally can only, a good session, like I think last year, we managed to clear 30. But normally it tends to be about 24, 25, because that's the only time we have. And the others will be held over, kind of, taken forward to the next session. And this year, as I said, I think we are sitting at over 120 kind of backlog, because we haven't been able to sit in March and June. I think we'll sit in virtually in October, later this on from the 26th onwards, we'll sit virtually, and we'll see how that goes. But my sense is that we are even going to decide less, because for obvious reasons like different time zones and all that, the office can only manage to put together a 3-hour day. Normally we'll sit the entire day. So I think what we'll have for this session will only be a maximum of 15 hours, which means I don't think we would be lucky to get through 15 cases in that session. So this is the process that follows, that there is a vetting system, and the committee itself sort of looks at them. Normally, there's very little to question in terms of what should come forward and what should not. Yeah.
Thank you, Professor. Thank you.
Thank you. Yeah. And so, as I think this is the one I was talking to in terms of the cases that come before us, figures 12 and 13. Next, please. Yeah, and I think I've already talked to this. Complaints lodged by international organization alone in conjunction with the national organization continue to play a significant part, especially in politically restrictive countries and those countries. And this is important because you remember that 87 and 98, in other words, the freedom of association obligations apply to all countries, regardless of whether they have ratified the conventions or not. Of course, where the countries have ratified the conventions, the impact and the extent of influence is much greater because in many cases or not, you can call upon those countries to, to conform by passing the reforms in terms of their legislation to meet the requirements of freedom of association. Those countries that have not ratified, you can't expect them as a matter of obligation to institute changes in their registration. But what you can't expect, and this is it, that you can expect of them to respect freedom of association and collective bargaining as fundamental rights of the Constitution. In other words, they shouldn't breach them. So that's what so they were the combined cases of national and international organization. There were 32 such cases in 2019, according to figure 11 that we looked at. And an interesting one that Professors Antonio and Anna might know of is that in 2014, the International Trade Union Confederation introduced the Global Rights Index. And this is supposed to be a source of information about the impact of freedom of association worldwide. And they ranked 139 countries. They ranked them against 97 internationally recognized indicators in terms of yardsticks of what amounts to, the respect of workers' rights as protected in law and practice. And out of those rankings, the indicators are 46 countries compared. Can you bring that up a bit, please, Victor? Yeah, it's cut off. Thanks. Of those countries, the denial was mostly against denial of freedom of association, which mostly affected trade unions. At times, employers were affected as well. The trade union rights were still violated, still be according to their index, and an estimated 59 out of 159 jurisdictions, more than a third, union rights were still, sort of violated. Trade unions were murdered in 11 countries, Bangladesh and Brazil, unfortunately. I don't know whether you recall. I'm not sure what year this is. In 2017, I think. I don't know. You might anyway. Brazil is implicated here. Bangladesh, Brazil, Colombia, Guatemala, Honduras, Italy, Mauritania, Mexico, Peru, Philippines, and Venezuela. But Venezuela, it was, I think, and Guatemala were the worst among these kind of matters of trade unionists. And the freedom of expression and assembly was severely restricted in 50 countries. And certain categories of workers were excluded from labor legislation in 84 countries. Victor, could you please bring it up a bit? The next. So that is the pattern, that kind of sort of took place under the ITUC index. And for research, I think Professor Antonio and Professor Anna, you might want to encourage scholars to engage with that index in terms of giving a picture of what is happening in those countries according to those 97 rights. I think that will be interesting. Yeah. Any comments of what, colleagues? Or questions, please?
Just a comment, Professor Evans. I noticed that the cases of mergers of union leaders are very they occur independently, regardless if if there's a democracy or not. I mean, like Italy, Honduras, Guatemala, Mexico, Peru. It's very similar what we identified with the crimes against reporters and press representatives.
Yeah, it's interesting, Professor Antonio. I mean, Italy is a sore thumb out of that, but you must remember, Italy has always had this kind of tradition behind, and it's not always, sort of in the workplace. There are a lot of agents that interfere, and that's the case as well, unfortunately, in Guatemala, that you have now sort of interference and intervention in workplace and trade union matters, not simply by the parties themselves, let alone the state, but other external agents, intra-union conflict factions, and all those sort of, unfortunately result in murders, in fatalities, and they count as murder. So this is not saying the states per se were responsible, even though in some of these states, the states were part of it. But sometimes it's non-parties, even to non-workplace parties that are responsible. That's definitely, I think, at least the cases that were looked at in Guatemala turned out to be that it's not simply the parties at all, but the people who intervene from external, hired hands, if you like. And in terms of Italy, what they call the black hand, that notion is, So you have these categories, and if you look, I mean, we looked at the figures 12, 13, 14, and 15. These relate to the interim reports. And if you look at the figure 14, you are dealing there with follow-up cases in 2019. And in terms of percentage, follow-up cases formed 13% of the total, whereas the follow-up cases examined were 87% of the total, And then you have in figure 15 status of the reports and the cases examined. You remember we referred to those percentages. Not calling for any further examination, that is closed, 34, 38%. Interim reports 22, 25%, and then active follow-up cases 33 out of 37. 33 out of amounting to 37%, and a total of 100. What's the next, Victor, please? Now let's come to Brazil, and this is where Professor Antonio and Professor Anna, I want to defer to you. Brazil is an interesting country in many ways, not only because of its size, but because I think of the level of industrialization and therefore sophistication of its institutions, and a mixed experience in terms of over the decades. where at times Brazil has easily been the leader in terms of sort of rice-driven kind of sort of trade unionism and social dialogue, and in others not. So what I managed to find here is that if you go, I don't know, Victor, is it possible to open the convention ratification? Is that possible? The conventions, there is a list of the conventions that were ratified, because those, I think, tell a story. It's not an irrefutable story, but what they do tell is that Brazil has got one of the highest, ratification records. And in terms of over the years, one of the highest kind of impact in terms of implementation. But it has, Brazil has ratified 98 conventions. And that translates to 7 out of the 8 conventions. Interestingly, and I want to hear from you, Professor Antonio and Anna, Brazil has ratified 98, but not 87. Very interesting. But in terms of the ratification, sort of record, it hasn't done very badly at all, particularly if you look at the core conventions. As I said, 7 out of 8. The only one there being 87. Further down, can you bring, yeah. But that in fact, the summary sums up very well. 98 conventions ratified, 7 out of 8 are core, 3 out of 4 governance priority, and technical assistance has got conventions. And this seems to be, because I think Brazil, historically, I think, I seem to recall this, as he is one of the strongest countries in terms of implementing the safe and healthy conventions. I don't know whether you share that, but this is the impression that is created, that when it gets to technical conventions, Brazil is among the top ones. It's only when it comes to the other conventions as well that you have this kind of sort of varied implementation from period to period. So what you have here is the 79 are in force, 23 have been denounced, and normally that denunciation you shouldn't read too much into it, because there have been quite a few conventions that have been done away with, and they're among those 23 denunciations, and then 4 instruments have been abrogated, and 1 has been ratified in the past 12 months. So the record overall for Brazil is not too bad at all. The question is, what is happening on the front of freedom of association now compared to, say, the past? If we go back, as I indicated, to the last decade, back to 2008, has there been any kind of noticeable difference in the implementation of freedom of association, not only with the law, and that includes case law, but also in terms of the actual practice of implementation? Professor Antonio.
Yeah, Professor Evance, I suppose part of the question is was debated in one of the cases you sent to us, the case 1487, complaints
Yes.
date January 23rd, 1989.
Yeah.
Because of the constitutional provision.
Yeah.
Basically, 2 constitutional provisions. One of them is partially revoked by the labor reform, the 2017 labor reform regarding the union tax. But the other one, which is I think even more important, is the one related with the monopoly of the union. If you have, it's sort of impossible to combine freedom of association and monopoly of union. And the thing is, to the extent that this is a constitutional provision in the Brazil 1988 constitution, it's difficult to manage this compatibility. There is one possibility. A couple of years ago, we approved a constitutional amendment providing the constitution the possibility to be amended by a very a process that is very close to the process of constitutional amendment. So just to go to the point, so we could ratify the 87 constitution by a very specific legislative process of very similar to the constitutional amended process, and it could be a way to bypass the constitutional obstacles that we have to face currently. I think this is one of the problems, but it's not all the problem. I mean, also, I think we have a legacy of a very state-guided and very state-dependent union system, and it's it's also part of the problem. And also, I think that we have a lot of particularities in our union culture, in our union background, regarding collective bargaining procedures, regarding the effectiveness of collective bargaining agreements. Well, there are a couple of things. I would say there's not just one fits all answer for this question, but the thing is, despite the fact that we respect, that we are very committed to the ILO, and even more committed currently than we were before. I mean, at first we didn't take that much importance to ILO. We are in the ILO. We had, since the foundation, since the creation of the ILO, on the founder. And but despite the fact that we respect the ILO, we have a cultural and historical problem to be respectful to freedom of association principles. Would you say? Would you agree with me, Professor Antônio Galvão Pérez?
I agree with you totally, Professor. This is a very difficult task to us to change this reality for the future. As you know, you are studying that for constitutional amendment. We will present a report to the society, but every time here in Brazil we have tried to change this reality. There are always lots of interests that always leave this evolution that is necessary to our freedom of association to the future, and this future never comes. That is the problem.
I would say also, Antonio, that our union leaders don't believe, they're not committed with the freedom of association principles. They don't believe in it. They think they're going to lose strength. They're going to lose political importance. They're going to lose the possibility to go to Brasilia, to the federal capital, and to lobby for their purpose. And that makes things a lot difficult, more difficult than it should be.
May I say something?
Yes, why not? Professor Wilson.
I guess it would be important to say that the same thing could be said about the employer association. That's why they had almost the same union structure of representation, and there is no question about the monopoly of the representation on the employer union also. And then we have both sides a very big resistance about the monopoly of the representation in Brazil. It would be a part of the explanation why we have, well, why we resist to have more than one union representing employers or employee on the same place, in some sense.
Yes, I totally agree with you, Professor Wilson. I remember when I was in the committee for elaborating the proposal for the union system, the Brazilian union system to be changed. It was 2008, if I'm not wrong, something like that. And one of the strongest resistance made from the employers. The employers organizations, they were very resistant to change both the union monopoly and the union taxes, despite the fact that they have a rhetoric speech against both monopoly and union taxes. Despite of this, they were more resistant than even the union leaders that joined us during the meetings by that time.
And even by now, when we eliminate the union tax, it's easier. It's not so hard to the employer association to keep our structure, because they have other sources of money by the moment. They are by the moment they have more. They are near the government. They are near the parties on some sense, and I guess they kept the main source or the political capital by now. But by the way, we are in a transition times since November of 2017 labor reform. I guess some things will change for the next years, I guess, in this aspect.
Mm-hmm. Yes, probably, Wilson. But one thing that I think should be stressed, highlighted, is the fact that we don't have only a very unique, very peculiar union system, but we have a labor system, a broader labor system, with a lot of institutions very peculiar and very remarkable in our tradition, such as the public ministry of labor, such as the labor courts. I mean, I wouldn't say that we can find another country with so strong, so broadly, so huge system of courts, of labor courts, totally devoted to labor conflicts and labor interests, labor subjects. It's very peculiar to our history, and to a certain extent, I think all this these are factors that are elements that closely related with the difficulties to change and the obstacles to change our corporatist and state guided heritage.
Professor.
Hi,
hello, Professor.
how are you?
I'm fine, thank you. I would like to ask you a question about this issue. It's a brief comment followed by a question related to that first case you showed us, case number 1487. The Brazilian, the so-called Brazilian labor reform of 2017 extinguished the compulsory trade union contribution, also called the trade union tax. This is, on the one hand, this is positive, I believe, because it's compatible with the principle of freedom of association. But however, on the other hand, the abrupt way in which it was done can totally remove the source of financial support for the unions, weakening them. And this happens precisely at the moment when the labor reform brings the concept of the prevalence of the negotiated over the law. I believe when employers negotiate with weakened unions, that can mean a significant loss of important social rights for workers, as has already been happening, in fact, in Brazil. How do you see the situation?
Well, I mean, as you say, it's not unique in Brazil, Paulo, because that's exactly the kind of problem that seems to happen. Is that the formal and the informal in terms of what the law says and what happens. I mean, both Professor Antonio and Wilson, I think, talked to the situation of a culture in Brazil that is state-led in terms of, and I wanted to find out to what extent actually that, because there is a similar, but I suspect different for different reasons elsewhere. So that my sense of that is that there is always a disjuncture between what you might call the law on the books in terms of legislation and then the law in reality. And many of the factors can be attributed to, first of all, to the nature of that legislation, whether they were around a particular kind of drive. In other ways, I mean, in every piece of legislation, in a democracy, there are, group interests, how it came, how overwhelming it was, and whose legislation it belongs to. But much more than that, there is the issue of institutions, and these are usually government-led. So you will find a situation where formally there will be one position and informally another. And if I may come back to this question of the government-driven kind of encouragement of unions, it's not unusual. In fact, in other countries, until for a very, very long time, what the ILO itself did in breach of its own kind of obligations was that it encouraged a lot of, say, African governments. It turned a blind eye to the requirement by governments to have one trade union center in these countries, clearly against 87 and 98. No diversity, no kind of democratic what there. And they used the excuse was that what the governments were trying to do was strengthen workers' rights, to give them some kind of concentration of power to face the employers. And it was very much in keeping with the tradition that had arisen there of dictatorship of the one-party state. So you order, sort of people to belong to one what, that way you can control them. They are more or less incorporated into government thinking. And all that now has come to pass. Even in South Africa. South Africa, after 1994, of course, there was always sort of multiple unions here. But after 1994, out of I suppose the uptake of new democracy, you had a huge kind of ruling party supported. In fact, they are still in alliance between the COSATU. This is the biggest federation, Congress of South African Trade Unions, and now they have broken up with a more radical one led by the metal workers. But besides that, there was always two other unions: a more radical Pan-Africanist one, and a more kind of sort of public-centered kind of union as well. So you have these contestations even in democratic spaces. But it's interesting. The case of Brazil sounds unique and interesting to me. Initially, I thought, is this simply a question of institutional kind of setting? But I suspect not. Because if I would really like to hear a bit more about how the state sponsorship is. Sponsorship in inverted commas. How does the state encourage these unions? And Professor Wilson also refers to employers. What are the factors that contribute to this? Is it simply the desire to go to Brasilia, or sort of to Caesar, so to speak, or are there any other dynamics in these various sectors that the state happens to encourage, for the sake of making the life of governance easier? Or is this sort of a worker-driven kind of solidarity? And if it's a worker-driven solidarity, what's its basis? Is it simply socio-economic? What is it much more political than otherwise? Because you see, if you look around, definitely in some countries in Latin America, as in South Africa, there are political alliances between the unions and different political formations, and they drive those ideological kind of pursuits in terms of what the stance they take. I don't know whether I've spoken to you or what. I'm sorry. Yeah, but your comment is interesting. Your comment is interesting. Yeah.
Thank you. Thank you, Professor. Thank you very much.
Professor Evans,
Yes.
because of the reality presented by Paulo, by Professor Paulo, today the unions in Brazil are trying to find other means to receive money from the workers. Because they don't have the compulsory contributions. Today we are trying to, in the collective bargaining instruments, to discriminate associates of and non-associates to the union, or trying to impose contributions by decision of the union assemblies. How do you see that? It is an anti-union practice inside the union. How does you or the CFA see this kind of practice?
Well, thanks, Professor Antonio. Look, the CFA does not kind of sort of concern itself with what is happening in a country as such. It is sort of concerns itself with particular complaints that are brought before it. But if I were to hazard a guess of the reality behind all that attitude, my sense is that the propensity, the chances are that they would tend to see it as a matter of union democracy, because you see, if you look at the compilation includes sort of guidelines about minority unions and all that within the world. And the reality of that in practice is that, particularly in a situation like you have, where there is no compulsory check-off, it does two things. First of all, it's bound to weaken the weaker unions. Secondly, it has been said, definitely in Africa, that, in some cases, it actually encourages unions to go and interact with rank and file, organize, which in a lot of African world that I'm aware of, is only when they broke up this monopoly that you are the unions really sort of competing to service their members. Of course, the downside to that is that you have increased conflict, inter-union conflict and violence, in fact, between unions. But so it's a very, that's the complexity in reality. But on the face of it, the CFA, we don't deal with systems as such, we deal with complaints. So if in fact the end result is that by these arrangements, somehow there is more breach of freedom of association and complaints are brought, we shall intervene. But we don't judge on the countries, country situation as such. You know, only in specific cases, which I think too is, I mean, speaking in you know, in a scholar's capacity, I think it's got limitations, it's got problems, because if you don't, you can't really, this idea that somehow a complaint comes out of a vacuum, that's not the reality. The complaints come out of real situations, and sometimes you instinctively one would think, look beyond what is the context of the complaint. We do that to a certain extent, but it's very, very limited. And you see, the approach that the CFA has is that whatever complaint comes before us, we take into account the circumstances. But that is is very limited. It doesn't, you know, in other words, what circumstances, the context. And usually it's a question of what capacity does the government have to implement what are the relations, the political, it's that kind of very soft thing. It's not really as tangible as one would like to. And normally, and this is, well, I don't know, I don't remember now, did I referred to the technical assistance, didn't I? It's the most successful kind of CFO intervention that seems to happen, where it's a question of where a government, and there are many governments, particularly in Africa, that are incapable of, you know, of implementing these conventions. And that's another dimension that you probably don't see too much of in Latin America. That you have in Africa the tendency of countries just ratifying conventions without, you know, stopping to ask, are we able to implement this? And then, of course, they don't. And now, at least in terms of freedom of association, whenever I meet state representatives, ambassadors that are struggling, I say, I have it within my gift to give you technical assistance. It will not, probably in all probability, it won't be Geneva. But the good thing about the ILO setup is that, in fact, the expertise, the hands-on expertise, most of it is not in Geneva, it's in the regions. So they can resort to regional specialists for technical assistance. And that has helped in terms of, I mean, I can think of one country in Southern Africa, what used to be Swaziland, it's a kingdom now called Eswatini. It has benefited from that intervention quite a great deal. Another one I think that I can think of is Vietnam. That is benefiting from that kind of intervention. So you seem to have a very interesting and complex situation in Brazil. But tell me, has there been a pattern of times when freedom of association thrives and times when it doesn't? And if there's been such a pattern, what drives it? Is it the socio-economic situation? Is it the political situation? Or is it the sort of the situation of unions among themselves or related to the workplace? I'm asking all these questions because, in fact, that's what we need to, at the end, in the fifth lecture, that's what we need to reflect on in terms of what it means for freedom of association going into the future.
Professor, I don't know if all my colleagues here agree, but I think that the problem is the fear to lose power.
Lose power.
So yeah, so we have
Professor Wilson refers to go to Brazil. Brasilia, you mean?
Yeah, because the unions here,
Yeah.
we have some very strong unions, but we have the same leaders. We also say in Brazil that you have some unions in Brazil that have owners, that because the leaders are the same for too many time, and we say they become owners of the unions. And if we change our constitution to a freedom model, these people will lose power. So I think this is very difficult to say to the current leaders. We need to change to a freedom of association model, and maybe you will lose your representation, because the workers will be free to create other unions or to elect other leaders. So I believe that this is the most difficult thing to face to a change.
No, I would tend to agree with you, Professor Antonio, that there is that natural fear, even though in some ways, yes, Professor.
I would just add some remarks about what Antonio just said. I think we have to look into perspective what's going on in the union representativeness and leadership around the world. I mean, we are facing very hard problems currently in terms of democracy, internal democracy. The representativeness of the unions, but I think to a certain extent, I think it's a global crisis in the Western countries, especially. If we look at what's going on currently in the United States or even in Europe, we just mentioned Italy. Italy used to be the nest of unionism and union strength, and well, the unions are facing very hard times currently, even in these countries that, like Great Britain, UK. I mean, the country where the Industrial Revolution was at first a remarkable phenomenon. So there are some other issues to be more carefully looked at and examined to understand exactly what sort of crisis we are facing currently. I mean, not only in the Brazilian perspective, but in the perspective of the unionism and the international and global point of view. I mean, at least I don't see this only as a localized phenomenon. I think it's part of a global phenomenon that we have to take into account.
Yeah. Okay, thanks. Thank you. Thank you. Victor, the next one, please. Unless there are any more comments. Yeah, the impact on Brazil, we have gone through that. And the attachment, I would just sort of encourage scholars to look at those attachments, the cases in particular. And I think the outlook in terms of discussion points, I think this is what we have been trying to do, that, these global phenomena and the factors that influence global and regional impact. I think we have discussed some of those for Latin America, and the need for a much more systematic understanding of what is happening, because what we have so far kind of bits and pieces of what's happening. And in fact, even when the GRURAD countries, those are the Latin American Caribbean group, confront me over this, I don't think I always say to them, we need to understand better what's happening in your countries. And the ILO hasn't come down to that. And I said, I think this is a scholar's kind of issue that we need to tackle. I would really encourage, from the CFA point of view, any kind of effort to look at these issues systematically in terms of a project, because it will be worth, I think, exploring possible support from the ILO. And we have also talked about what accounts for the volume and nature of cases in Latin America, which is also tied to that. But beyond this, I think one has simply got to say that both the global and regional kind of sort of developments have been affected. And this is, I think, an issue should come back to, by what is happening now, by what is happening, economically, not least, sort of by the COVID impact. We're going to look at that. But also, I think, by what is happening in the matratro system. And that, in a sense, is very different from the, even before the pandemic. That, as you remember, I started by suggesting that the ILO, the establishment of the ILO, was a product of a certain kind of matratro consensus, which went up and down until it has reached a point now where smallest kind of, so not as important, to say the least, that countries now don't feel as much obliged to follow the common good, if you put it that way. And interestingly, for those of us who are also interested in regional integration, like BRICS, these regional kind of sort of economic blocks have tended to weaken. That was not the intention. I mean, the intention, of course, of BRICS, for instance, is that, look, we need to, the South needs to have a space where they can relate to each other and then try and develop a different narrative from the global North. But the impact of that overall is that it tends to weaken the global matratro system. I think it's those factors that are interesting to look at and how they affect our field, the field of, not only international labor standards, but in, freedom of association and collective bargaining in particular. So I think for today, obrigado. I'll leave it at that, unless there are more any comments or questions, please. I'm still awake. Yeah.
Any questions? George, you want a question? Anyone? Okay. Again, Professor Evans, thank you very much for one more wonderful and delightful lecture.
It's my pleasure. Obrigado. So, and next week, we are going to look, I think that will be interesting because some of the issues that you and Professor Wilson have been raising and Professor Paulo is about freedom of association and democracy. That's what we are going to look at in terms of the global situation. And then the last one will be reflecting on the future. Thank you. Thank you very much.
Thank you, Professor. Thank you, Professor Kalula.
Thank you. Thank you very much. Yeah. Obrigado.